Good afternoon, dear Medyascope viewers. Welcome to our exclusive discussion on Turkey-Greece tensions in the Eastern Mediterranean from a law of the sea perspective. For this exclusive discussion, I am joined by two public international law experts, both of whom have significant works on maritime delimitation law. Yunus Emre Açıkgönül and Nicholas Ioannides. Welcome both of you to the program.
Thank you.
Thank you.
Well, let's start with a short account of what's going on, how you define the current problem, which has caused big tensions between Greece and Turkey now in the East Med. So let's start with you, Emre. How do you define the problem now from a legal perspective?
First of all, Edgar, thanks for having me once again. It's a pleasure to be here, and particularly to discuss this issue with Nicholas, who is a true expert in the field, and he studied at Rhodes Ocean Law Academy. So he's from the region. It's a bigger honor to discuss this issue. So the Eastern Mediterranean Sea problem has many aspects. So there are issues related to politics and diplomacy. There are legal issues as well. So what I see here is specifically a maritime boundary delimitation problem. It is a problem occurs in different parts of the world as well. Over 400 maritime areas overlap in the world, and over 300 disputes were discussed, and half of them resolved. So Eastern Mediterranean Sea dispute is one of those disputes. Basically, we are trying to find an answer. Who owns what part of the Eastern Mediterranean Sea? What is Turkish boundaries and what is Greek boundaries, or Cyprus, or whether Turkish or Greek Cyprus, or Egypt? So that's what we try to find an answer, and we have all these disputes in the region right now. Contrary to land boundaries, on the sea boundaries, there is always an uncertainty because land borders are always defined. There were historical wars in the past, and for example, Turkish-Iran border was almost more or less the same throughout the history. But maritime law is a new developing field of law, and that's why in the last century we're trying to find answers. Who owns what part of the sea?
Yes, so I would like to ask the same question to Nicholas. Do you agree with Emre's definition of the problem now?
Yes, first of all, thank you, Edgar, for inviting me. I'm glad to be with you. By way of disclaimer, I'd like to stress that the views I'm about to express are strictly personal and do not reflect the views of any institution, organization, or government. So in answer to your question, yes, I agree in principle with Emre. I believe that there are three aspects in this current standoff in the Eastern Mediterranean. The first one is the entitlement of islands to maritime zones, and we could elaborate on that later on. The second one is the effect of islands in a delimitation, and the third one is the legal framework governing activities in undelimited maritime areas. So we can see how these rules interact in the current situation in the region, and I believe that today's discussion will shed light on the developments through the lens of international law.
So thank you, Nicholas. So we can start with the maps and with a more technical discussion on what's going on, and it will be a legal discussion, as we have always underlined. The issue has been discussed in Turkey with a reference to a conception of what we call here in Turkey a blue homeland. And thank you, Emre, for preparing all these maps. And let me show the first map, if you don't mind, here. So Emre, can you please elaborate once again in English this time?
Sure, of course,
what is blue homeland?
Yes, so blue homeland is, it was a doctrine there since 2006, but we have seen it become a kind of official government policy since last year, from 2019. In the next map, next image, you will see President Erdogan is giving a signing a document in front of this map. So we see different versions of this. This is, I think, what believe Cihat Yaycı, he's also an expert in this area, draw. So in this map, Turkish traditional Eastern Mediterranean maritime claim is expanded. It's now connecting to Libya on the west, Lebanon, and Israel. So this is a little bit expansion from the traditional view. In this photo, we can't see what exactly is the claim around island of Cyprus in this specific photo, but I assume it is the same as what I showed. There are different versions, as I mentioned. So yeah, this is the maximalist claim Turkey is bringing these days, and which is pretty popular in Turkish media as well. We keep seeing this map everywhere.
Yes, Nicholas, how is the conception of blue homeland and these maps seen, commented on in Greece, in Cyprus? How do you define it?
Well, as you can tell, this idea of the blue homeland, the whole concept, seems quite expansive to us. And the main reason is that it's based on the long-standing position of Turkey that islands do not have their own maritime zones. And when it comes to delimitation, they should not receive full effect. And if I may elaborate on that, I'd like to point out that islands, according to the Law of the Sea Convention and customary international law, it's Article 121 of the Law of the Sea Convention, are entitled to all maritime zones. That's the rule, that's the principle. But when it comes to delimitation, islands might not get full effect, depending on the circumstances. But we need to bear in mind that there are two dimensions in that problem. The first one is the entitlement of islands to all maritime zones, and the second one, that in delimitation they might not get full effect. These are two different aspects of the problem.
In this next map, we can also see the Greek claim here. Okay, Emre, what does this map show us?
So this map is a strict application of those two rules Nicholas mentioned, Article 121 of UNCLOS, which says islands have entitlement to continental shelf and exclusive economic zone. And also, second principle, that the limitation should be based on equidistance line or median line. And once you robotically, strictly implement these two principles, this is going to be the result. So this is basically a Greek claim. So it's unacceptable from Turkish perspective, and I believe also from international law perspective, we have ample evidence that this is also on the maximalist side from the Greek side. So yeah, this is the definition. Here there is a text on the map. It says Meis. It's Turkish name for Castellarizo, so we should just correct.
Mm-hmm. Okay, Nicholas, Emre underlines that the Greek claim, which we can see now in this map, is against international law. Would you agree with that statement?
Well, I wouldn't agree with that, because what we see on that map is a claim based on the median equidistance line. We need to stress the importance of the median line. As you know, the median line has been the starting point for maritime delimitation, especially after the 2009 Black Sea case. When applying the three-stage approach, international courts and tribunals commence delimitation by drawing a provisional median line. And then at the second stage, they check whether any relevant circumstances dictate a modification of that provisional line. And at the third stage, they check this proportionality. So I would argue that pending delimitation, claims based on the median equidistance line are claims made in good faith that should be discussed, and that is also supported by the travel preparatoire of the Law of the Sea Convention, where the drafters believed that reference to the median line should be included in Articles 74 and 83, but eventually it didn't. But we can see that in the ICJ jurisprudence, specifically in the Jan Mayen case in 1993, the court explicitly mentioned that prima facie, in principle, median line may also lead to an equitable result. So we should not abandon the median line. We should not reject outright the median line. I believe that we should have that claim as our starting point, and then discuss the specificities of each case. And as the ITLOS has said, the International Tribunal for the Law of the Sea, in the Bangladesh-Myanmar case, each delimitation case is unique and it should be examined according to its own merits. So there's no general rule, there's no blanket rule applicable in all delimitation cases. We should examine each case on its own merits.
Do you have something to react, Emre? Maybe to what
I do. I think there are lots of common opinions we have with Nicholas. So I also believe a median line should be a starting point for a delimitation. It's an established case law now. Like, courts are consistently repeating the same argument. We need to start with a provisional equidistance line and then adjust the line in the light of special circumstances. So these special circumstances could be presence of islands, promontories, small rocks, even shape of the coastline. So these are relevant circumstances. That's how it's called by the court. So we should start with the median line or equidistance line. These are almost the same. One is on the opposite coast, the other one is on the adjacent coast. The question here is, the island of Castellarizo, the small island we will discuss in the next slides, photos, is that island starting point for an equidistance line? So this is one question, because as Nicholas referred, since 2009 Black Sea case, now courts are using their discretion where I'm going to start the reference point for a median line. Like, is median line between Greek mainland and Turkish mainland, as in UK French case, or is it between Rhodes, island of Rhodes, Crete, and Turkish mainland, or is it between Castellarizo and Turkish mainland? This is the question. So this is another discussion which is not being talked about, which is very important, because there are cases we will see in the next slides, as I said. For example, in the Serpents Island case, San Martin's Island case, and even Nicaragua, Colombia case, there were islands situated on a extreme remote location, and court said, I'm not going to start the base median line taking reference this island. So I'm going to ignore this island when I'm making the median line, and then I will give an effect to that island. So the discussion is how court will treat Castellarizo. There will be argument from both sides, but my personal opinion, Castellarizo is too remote, too small, half size of San Martin's Island, which was also ignored in deciding the base points. That's how it is called. So that's one thing. Second, let's say I will still find extreme to expect a court will define the median line between Greek and Turkish mainland. That's not going to happen. So the best case scenario would be the median line between Dodakenes Island, except for Castellarizo. This includes Karpathos, Chaos, and Rhodes Island. And then after median line is drawn, maybe adjusting the line in favor of Turkey in the northern part, so that Turkish mainland can open to the south projection. And then maybe being more in favor of these islands on the western and southern part. So that's the simple, equitable solution I find.
Okay, I will give the floor to Nicholas, but let me first show the map, which shows both the Greek and the Turkish claims, as well as what Emre thinks is in accordance with the international law, and then we can continue discussing the issue. Here. Here the blue lines is what Emre thinks is in accordance with international law. So, Nicholas, would you agree?
Well, indeed, in the first place, I would agree with Emre that international jurisprudence has given reduced effect or no effect to small isolated islands. That's true. But bearing in mind what I mentioned earlier, the Eastern Mediterranean case is different. So we need to take into account several factors. What I'd like to stress is that Castellorizo is not a lone isolated island, but I would say that it is part of a greater, broader geographical and administrative complex group of islands, namely the Dodecanese. So when it comes to delimitation, we should not take into account the islands separately in the region. We should take them into account as a whole. For instance, we need to add the sum of the coastal lengths of Castellorizo, Rhodes, Carpathos, and other islands projecting into the area, into the limitation, and compare that sum with the coastal length of Turkey. I believe that would be a more equitable solution. I haven't done the maths. I can't tell what's the ratio, but I believe that we cannot separate Castellorizo from the rest of the islands of the Dodecanese because it's been a complex for centuries. And in 1932, when Italy delimited maritime boundaries with Turkey, and in 1947, when Dodecanese was ceded to Greece, it was ceded as a complex, as a group. So we should not overlook that detail, and that might change how things will come. What the outcome will be. I'm not a negotiator. I'm not a judge or arbitrator. I'd like to refrain from giving a solution right now, but I think that there are more factors to be taken into account than what meets the eye.
Okay. Emre, Nicholas says that the island of Castellorizo, which we know as Meis in Turkish, is not an isolated island. So how do you react to that?
So this claim has a definite value. If the issue is resolved through negotiation or conciliation, this argument will have even more value. But when it comes to a court decision, so right now my map is based on if the dispute goes to an international court or arbitral tribunal, what would a court say? So in court decisions, we have seen similar arguments brought by the parties. And the most striking one, similar one, was Nicaragua-Colombia case, where Colombia wanted its islands, group of islands, be treated as a mainland. So, and the court said these islands are separated from each other. Some of them are 100 nautical miles away. Not the same case in here, of course, but and it said these islands should not be treated as though they were a continuous mainland coast stretching over 100 nautical miles and cutting off Nicaraguan access to the seabed. So that was a decision given in Nicaragua case. Similarly, in Bijagos Island, we will see in a map, a similar argument was brought by the parties, and court ignored those islands because they were disproportionately distorting the median line between the states. As I said, the result might be different, as Nicholas suggested. Courts may take, maybe not the courts, but in negotiation, it's going to be taken into account. But what I see, historical claims, they play more role in negotiations, but not in court decision. It is very exceptional. There are samples, but very exceptional. But if we go to, do you mind if I go to a map, Nicholas, unless you want to add something? So can we go to the map? So in this map, we're going to see now, the delimitation is between two mainlands, United Kingdom and France. So in this map, what UK argues is that the delimitation should be between Channel Islands belonging the UK and France. So at the end, the court said this won't result in equitable solution, and the reasoning was simple. These islands at the arm of a French Gulf and just only 6 miles away from France. And it used exact wording. This, if we define the boundaries between these two islands and the French mainland, the result will be basically distorting the general geographical balance between two countries. And then the final final delimitation line was between mainlands, and islands were giving enclaved zone in the north. And can we go to the next map? So when I flip over this map and put it next to the Eastern Mediterranean geographical area next to this map, and when I copy paste, you don't copy paste in court decisions, that's for sure. I'm just illustrating it. When I copy paste these islands to Turkish mainland, which is Meis, so the result would be, for me, pretty simple. These islands, Castellarizo is too remote, too small, and extremely distorting and cutting off Turkish projection. And the result would be this. If you go to next map, one more, and then I'll let Nicholas comment on this.
The sixth one?
Okay. Yes, please. So in the next map, we see another case between France and Canada. There are two French islands, very similar geographical location to Castellarizo Island. On the wrong side means closer to other countries' mainland. And these islands are called Saint Pierre and Miquelon. France asked these islands to be given full effect against Canadian territory. But court limited these islands into a 12-mile zone on one side, 24-mile zone on the other side, and then gave a corridor down so that these islands can have opening to high seas. And once we copy paste again, next slide please, copy paste this specific decision into Eastern Mediterranean Sea dispute. So the result will be, again, a limited zone to Castellarizo instead of full effect. It's semi-enclave, and an opening to the south. There won't be an opening here because there is no high seas. In that case, there was a high seas, international waters that court wanted to give access to Saint Pierre and Miquelon. But here we don't have that. The area, the distance between Turkish mainland and Greek, Egypt coastline is less than 400 nautical miles. That means there is no international, there is no high seas. So there is no need for this corridor. So same result is going to be enclave, as I argue.
Mm-hmm. So Nicholas, Emre thinks that these cases could be considered as a precedent by a court for the case between Greece and Turkey. Would you agree with that?
Well, first of all, the principle of legal precedent does not apply in international law. So courts and tribunals are not obliged to follow the previous case law. But of course, they draw arguments and conclusions from their jurisprudence, that's for sure. But I would argue against the automatic application of previous case law to any other case. As I said, the ICLOS and later on the ICJ in the 2018 Costa Rica versus Nicaragua case clarified that each case is unique. So I fully understand the two cases, the rationale of the two cases. I think that the circumstances were different. So I'll repeat that Castellarizo should not be regarded as an isolated isolated islands and should be taken as part of a whole group. And another remark I'd like to make is that as regards the cutoff effect, there's an interesting article written by Emre on the cutoff effect. I'd like to remind you that in the very same case, in 1992 Canada-France case, the Saint-Pierre and Miquelon case, the tribunal said that we need also take into account that there shouldn't be any cutoff effect for islands as well. So it's not just for continental lands. We should also bear in mind that there shouldn't be a cutoff effect for islands too.
Mm-hmm. Emre, what do you react to that?
So, I mean, that's right. I think it was Bangladesh-Myanmar case court said, trying to prevent cutoff effect on one side should mean that we are cutting off the other country. So it has to be mutually balanced way. But again, Professor Malcolm Evans, Nicholas will know, he has public international law handbook study. He's a real legal philosopher and focused on public international law. And he mentions that if delimitation is about coastal geography, it seems it's primarily mainland coastal geography. And also Professor Al Fering also said something similar. Basically, islands are features within the sea and they are prone to domination of the mainland. So that's true. We should make it mutually balanced way, as it was in Nicaragua, Colombia case. But the priority is always a mainland coast, which has over 1,500 kilometers projection towards Eastern Mediterranean Sea, versus a island which has only 6 kilometers length and 3 kilometers height in a size with 500 population. So that's true. Like as Nicholas mentioned, entitlement under Article 121 is out of question. Islands do generate maritime laws, maritime areas, exclusive economic zone, continental shelves, but to do it on an equal basis against a mainland is not recognized. And that's a different discussion. We all agree on that. So for me, it's clear there is probably this, if this goes to a court, this will be one of the best examples of how a small island can cut off a huge maritime opening of a mainland. So I see very little possibility of granting more than enclave, but could be, particularly in negotiations. It's definitely a good argument.
Mm-hmm. Okay. Do you have other cases to refer to?
We can go 8 if you don't mind. Okay. Number 8. So Nicholas, please feel free to join at any point, because my arguments are based on my opinion. So, and also these are maps I brought, so I want it to be balanced, and you also have a chance to, bring your perspective. So this is another map. This is a delimitation case. Nicholas also referred between Bangladesh and Myanmar. We don't see clearly, but there's a very small island at the beginning of the delimitation line. There's a semi-enclave, semi-circle right in between. This island belongs to Bangladesh, but it is closer to Myanmar mainland. So the same argument was brought here by Bangladesh, saying that this island needs to be respected as part of Bangladesh coastline and needs to be given full effect. The court said first, the tribunal, sorry, I cannot use St. Martin's Island as a base point in the construction of provisional equidistance line because it is immediately in front of the mainland of Myanmar on the wrong side, same as Castle. Second, giving any effect to St. Martin's Island for the purpose of delimitation of exclusive economic zone and continental shelf would result in blocking seaboard projection of Myanmar, and then it would cause distortion of the delimitation line. So I am going to ignore this island for this purpose, for the exclusive economic zone delimitation. If you go next map, maybe after Nicholas can make comments, you will see, sorry, there's no comparison on this one. Sorry, that's all, yeah.
Okay. Nicholas, do you have something to say on that?
Well, It's the same. It's the same argument I used earlier. So maybe there's any more maps, some similar cases, we could go through them and then have a general discussion.
But if I quickly go through all the maps and then we continue.
Yeah.
Keep going back to Nicholas and asking his opinion. Yeah. So the one important thing is St. Martin's Island is almost the same size as Castellarizo, but has 8 times more population. We need to address that too. So can we go to next map? So in this map, another delimitation case between Guinea and Guinea-Bissau. By the way, as Nicholas said, a decision precedent is not automatically binding on other states. So every case is unique for sure. But this is some, I need to add something. I actually wrote a publication last year about this. How international court decisions are binding on other future disputes. What is the authority? And my conclusion was based on the language of the court, saying that if there is a consistent pattern of case law, this becomes more than a subsidiary source. It becomes effectively a binding authority on future disputes. That was the conclusion of my article. So I believe if there is a consistent case, consistent pattern, those arguments are very, very, very important in future cases, because what we see in all cases, they are keep referring previous decisions. So you will see in Myanmar case, half of the case about half of the section about concave coastlines is talking about or quoting directly from North Sea continental shelf case, or in Barbados and Barbados case, Trinidad and Tobago, we see a lot of references to other court decisions. But let's come back to the map again. So those Bigajos Islands, they are big islands, as big as Dodecanese Islands. And in this map, on the right side, those islands are ignored in deciding the delimitation line. So Guinea-Bissau suggested to make an equidistance line, and the court decided to deflect that equidistance line in favor of Guinea, so that there is coastal opening for Guinea. So when we use a similar analogy here, again, so the equidistance line needs to be moved to where I find equitable, to the east, so to the west, sorry, to allow Turkey to have some coastal opening projection towards south.
Mm-hmm. So Nicholas, why do you think these cases cannot be considered as a precedent for Turkey-Greece case, and particularly for the island of Castellarizo, which Emre has been consistently referred to?
Well, there can't be a precedent from a procedural aspect. Of course, I agree that the principles and rules applied in those cases are universal, and they can be used. They can be used by courts and tribunals in every case. However, the factual situation changes in each case, and that's what I wanted to point out. In the last case, the Guinea-Bissau Guinea delimitation, as you can see, there was no enclavement. There was a slight change. And that's what I said at the beginning. I said that, okay, the median line is it's a claim made in good faith, of course, but it might change either in the negotiations or during a court procedure. So that's why I was trying to make clear that we shouldn't automatically apply judgments, awards to our case, because as you can see, if we take the argument I used earlier, that Castellarizo is not isolated, then the whole picture changes. So we can't be sure about the outcome of a future delimitation. It depends on the facts and the understanding of the negotiators or the judges and arbitrators. That's why it's a quite complex case. And I saw a map earlier showing the limitation between Cyprus and Turkey and the Greek islands. I don't know if you can see that.
Let me show the map. So Yeah, here.
Yes, a very interesting argument stemming from the ICJ jurisprudence again in the Libya-Malta case, where the court took into consideration the fact that Malta is a state. So even though it's the Libyan coastline is 9 times longer than Malta, and of course Libya got a broader maritime space, statehood played a role in the court's decision. So it would have been different probably if Malta was an island belonging to Italy or another state. So this is another factor we need to take into account when it comes to delimitation in our region. So you can see there are several arguments we need to examine prior to giving an opinion as to the outcome of a delimitation. And as I said earlier, but I think we're not in a position to do so. But of course, Emre's attempt is very interesting, even though I don't agree. But I think we should focus on international law and try to come up with solutions, with legal, political solutions in order to avoid tension.
Mm-hmm. So I will ask last questions to both of you, but before I want to give the floor to Emre, because Emre, last time in our broadcast you had also referred to the case of Malta with Libya. So would you want to add something to that, to what Nicholas said?
I mostly agree with Nicholas when it comes to Cyprus, because Cyprus, whether it is Turkish Cyprus, Turkish Cypriot side, or Greek side, it is we should treat as an independent state, not a dependent island as in Rhodes or Castellorizo. So court was pretty straightforward. Like, you can't treat Malta as a incidental feature on the map. It's an island. It's a statehood by itself. So this is very important. So what court did on that particular cases? So it said there is a pronounced disproportionality in the coastal lengths. Libya is 9 times longer than Malta's relevant coastline. So I'm going to adjust the line in favor of Libya to the disadvantage of Malta. So that was a striking decision. And what I believe, this factor will play the same role in Cyprus and Turkey delimitation, because when we are making the delimitation, the court is likely to separate the geography into two: one where northern Cyprus and southern Turkey overlap, and also the west of Cyprus island, where the coastal relationship is adjacent, not opposite. So in this section, specific section, Turkish coastline is 7 times longer than Cyprus relevant coastline. So this is very similar to Libya-Malta case, which was 8 times longer, or Greenland-Jan Mayen case, 9 times longer in favor of Greenland, or Nicaragua-Colombia case, which was 8 times longer. So this will be a factor. Second factor would be, which wasn't there in Libya-Malta or Greenland case, or even Nicaragua-Colombia case, is the cutoff effect caused by the adjacent coast. So here we see the cutoff effect even more extreme, because it's only 40 miles distance between Cyprus and Turkey. Plus the coastline relationship is adjacent. So huge, and the Turkish coastline is longer than Cyprus. Naturally, it's being cut off more than Cyprus. So taking into these considerations, I believe Cyprus will not receive full effect. It could. I'm not completely leaving out of the possibility. That's the weakest point of Turkish arguments. But in any case, we should not even discuss about limiting Cyprus with a territorial sea zone with a 12 miles. So that is out of question. It will receive no credit, no respect from any authority, any international court, any arbitral tribunal. I mentioned before, if the issue goes to arbitral tribunal, even the judge appointed by Turkey itself will not agree with this. So this is extreme. So Cyprus is an independent state and needs to be treated as an independent state.
So this is basically what explains the difference between the Turkish claim, I mean the green line, and the blue line.
Exactly. So red line is full effect. Green line is only giving territoriality. What I believe, that blue line could deflect towards Cyprus or towards Turkey. But what I believe is fair based on those two arguments I brought.
Okay, thank you, Emre. And now let me ask both of you the last questions, and it will be the same question basically. So now the problem is basically a political problem. Even though we have been discussing the issue from a legal perspective, from the perspective of the law of the sea, but still, from a legal perspective, how do you think the parties should proceed from now on in order to avoid escalating the tensions and finding a peaceful and equitable solution? Nicholas, please, let's start with you.
Well, before I answer to your question, I'd like to make a clarification. You both referred to Greek and Turkish Cyprus. I need to point out that there's only one recognized state, the Republic of Cyprus, and in the occupied areas, of course, an illegal regime installed by Turkey. So just to make the point. And to answer to your question, I'd like to say that we need to solve this problem either through negotiations or preferably, in my view, to have recourse either to the ICJ or to an arbitral tribunal. So I believe that a 15-judge panel would be appropriate to solve this problem. International law experts having all the details, all the circumstances in front of them, could reach, I believe, an outcome which would be acceptable by all the interested parties. That should be the way forward. Let's solve this problem according to international law. That should be our yardstick. And I believe that we should avoid any further tension. We should submit the dispute to an international dispute settlement mechanism in order to delimit the maritime boundaries in the Eastern Mediterranean and be able to avail ourselves of the benefits of the hydrocarbon bonanza and all the other benefits deriving from the sea.
Thank you, Nicholas. Emre?
I just can echo whatever Nicholas said. So the most undesired result we want is a military confrontation, and even if it is not there, it is having a political tension is not helpful to the prosperity of the region and to the countries. Historically, Eastern Mediterranean Sea was the symbol of stability in the north. Like even during Roman Empire, the uninterrupted supply of grain was the stability in the north. Today, we're talking about East Med pipeline, which could help prosperity of Europe with the natural resources are being carried to and transported to Europe. And it should be a sea of peace instead of dispute, conflict. In terms of the resolution, I agree also it should go to an international adjudication or arbitral tribunal. It could be ICJ. But what I see challenge is, apart from delimitation issue, there are other matters. Now it is a bigger discussion due to sensitivity or national emotions involved. For example, Cyprus issue. So it's a huge issue. Before resolving Cyprus, or Turkey recognizing the Republic of Cyprus, or Greece recognizing Northern Cyprus, how parties will go to an international court of justice, and it might result in recognizing Greek side for Turkey, which is against its long-standing established foreign policy. Second, also related to this, Greece would not risk of losing the huge, massive maritime area around Castellorizo, and if it goes to court, so there is a high chance that it will be enclaved. That's what I believe. So it's a big risk for Greece, but still, there's a chance. What I believe the best solution would be, even though I am still more in favor of international adjudication, maybe a conciliation group formed with some diplomats and international law legal experts. So that's what we're lacking. So the communication between Greek and Turkish side was handled by only international relations experts, diplomats, and sometimes military staff. So what I believe, military when military is involved in a decision-making policy in such a sensitive issue such as this, there will be less hope for a resolution. A group of Greek experts, including Professor Mutovas or Nicholas himself, who is proponent of the peace and prosperity and the friendship between countries, than pure nationalistic, people with pure nationalistic approach. Or on Turkish side, maybe Ambassador Turman, whoever we think, Ünal Çevikgöz perhaps. So when these people who believes in the solution comes together, there will be a solution. Nicholas said at the beginning, he said median line should be a starting point for this negotiation, which makes sense. If you believe it's a starting point, then there's a room for discussion. But again, Turkey should quickly abandon this extreme claim of blue homeland, which I think doesn't help any hope with the resolution of the dispute.
Yeah, thank you very much, both of you. I mean, so far the conventional problems between Turkey and Greece has been in the agency, and those issues were predominantly bilateral. But now in the Eastern Mediterranean, the issue has become very much international and multilateral, including the Cyprus issue, because it is at the center of the issue as well. So we hope, we all hope for equitable and also peaceful solution between Greece and Turkey and all other interested parties and states. So thank you both of you, Nicholas Ioannides and Yunus Emre Açıkgönül, for joining me for this discussion.
Thanks for having us.
Thank you for this interesting discussion.
So, dear Medyascope viewers, thank you for joining us in our exclusive discussion on Turkey-Greece tensions in the Eastern Mediterranean from a law of the sea perspective. Have a good afternoon.